The court has decided that 4 pages of a letter from Kouri Richins' jail cell must be released to prosecutors. That's what we're going to be discussing today. Hello. My name is Katie. This is Katerina, and this is where we discuss true crime, politics, and current affairs. If you are a returning viewer, you know how this goes. We go through an article, I give my uneducated opinion, and we continue the discussion in the comments below. Today we are back on the Kouri Richins case. It's been a hot minute since we covered this. It actually went quiet for a while, which is unusual in this case. Yes, I know, baby girl. Apologies if you can hear lawnmowers outside. It's a Sunday, Sunday, therefore people are doing things. So, as I said, the court has decided that 4 pages of a letter found in Kouri Richins' jail cell must be released to prosecutors. Let's go through that today. So this is the latest in the legal battle in the case against accused killer Kouri Richins. Attorneys have argued about evidence found in her jail cell and whether it should be made public or not. Her lead defence attorney has claimed that the letter was specifically addressed to them, so they believe it should be protected by attorney-client privilege. Back in September, deputies for Summit County Sheriff's Office seized the document known as the Walk the Dog letter in Kouri Richins' jail cell. Court records state this letter was found the same day as another 65-page packet that was handed to her defence attorney. On Friday, the 23rd of February, attorneys argued on whether the other letter should be submitted into evidence or not. Letter number 2, as it's known, was found in an envelope specifically addressed to Kouri Richins' defence attorney, Sky Lazaro. However, former prosecutor turned criminal defence attorney Jeremy Dias said not all communications between a defendant and their attorney are automatically protected by attorney-client privilege. Quote, if you're talking about specific legal communication, that's talking about the case, even if there are potentially some admissions in there. Those sorts of things, if they're being communicated to the lawyer, those are things that are very squarely attorney-client privilege, end quote. The judge in this case, Judge Mrazik, we like Judge Mrazik, did decide, a third-party attorney would be brought in to decide what is protected communication and what isn't. There are a couple of things working against Kouri. For example, she's claimed that the writings were part of a fictional book she was writing. Dias commented, I think you're really getting into the grey area there to the point where I don't really feel it is privileged communication, and I think the state really has a legitimate argument. End quote. Also, if she showed letter number 2 to her family members, like the prosecution claims, it would not be protected. Dias said attorney-client privilege is so delicate he doesn't want family members in the room when he talks to his clients. Quote, you ask different people to leave to make sure the attorney-client privilege stays intact, because if someone else is there, you waive privilege, according to Dias. On Friday, 23rd, the court decided the defence has to disclose 4 pages of letter number 2, saying that the court finds under Rule 16b(1) that the defence is required to disclose the 4-page document that is referred to as letter number 2 because there is good cause, and therefore the motion for good cause is granted regarding letter number 2. However, 33 other pages are protected by attorney-client privilege. Court documents show a preliminary hearing has been set for April the 17th. However, Kouri's attorneys told 2 News the hearing had been rescheduled to May the 15th. Sky Lazaro, Kouri's attorney, recently spoke to CBS's 48 Hours, and she believes the prosecution will have a hard time proving one key aspect of their case. quote, they have to prove that she obtained drugs and gave them to her husband. Unless they can connect those dots, they're going to have a hard time proving murder in this case. End quote. A spokesman for Kouri Richins' family says that he didn't use opiates, so they don't believe he went to Mexico to buy the fentanyl that later ended his life. Thoughts? What do you think? So some of it has been allowed. So the envelope contained the novel and another writing that another inmate wrote to Kouri, and that is the one that is dubbed letter number 2. And the judge has decided that isn't privileged. This novel is privileged. I'm not entirely sure how. I mean, I know it was in an envelope that said attorney-client privilege, but if it's fiction, I don't understand how it's covered by attorney-client privilege. But anywho, so the preliminary hearing has been set for May. And because I am not familiar with any sort of court system, never mind the American one, I had a little Google. A preliminary hearing only applies in felony and Class A misdemeanor cases. The purpose of a preliminary hearing is to determine whether probable cause exists to show that the crime was committed. Check. And probable cause exists to show the defendant was the person who committed the crime. Check. At the hearing, the judge listens to witness testimony and receives evidence. If the judge finds probable cause that the defendant committed the crime, the defendant is bound over for trial. If the judge concludes there is insufficient evidence, the case is dismissed. Charges may also be amended at the preliminary hearing. So this is where we decide if we actually go to trial. See if it feels like it's taken forever. Eric died March 2022. Kouri was arrested May 2023. And now we may not get to a preliminary hearing until May 2024. But I still don't get how this book, allegedly, is attorney-client privilege. Do you understand? No. We must remember, as of today, as of recording this video, Kouri, while she is sat in jail, is presumed innocent because there has been no trial. And when commenting about this case on social media, please keep in mind that there are children involved. They have lost their father and their mother is sat in jail. So you've got to feel for them. But do you think that this will go to trial at all? Or do you think that the defence has a legitimate argument with but you can't prove she bought the medicine that ended Eric's life? No, sorry. I think they can, because, was it Carmen Lauber testimony, etc. But I think that they're going to try and question her legitimacy, aren't they? And then they have to prove that Kouri put the medicine in the drink that Eric took that ended his life. And if I remember rightly, they haven't even tested that cup that he drank from. I mean, isn't that like Police 101? I don't know. Maybe it's just me. I'm going to put you down. Is that okay? I kind of need my hands back. Okay. Katerina wanted to join us today. I have put the minutes for the motion for good cause disclosure in the description below. There's not really that much in there. It's just saying, yeah, you need to give this, but not this. If you are interested in seeing the actual walk the dog letter, we went through the whole letter. It's entertaining, at least. So again, I will link it at the end of this video. And that is it for today. That's the latest update after it's been quiet for what feels like forever. There was a point where I couldn't keep up with this case, but now it's slowly trickling back in again. Don't forget to come follow me on all the socials. I do share other news articles, crime articles, etc. Don't forget to follow. and like and subscribe and share and comment. All of that good stuff helps the channel to grow. I think that's it, isn't it? Anywho, I hope so. Thank you for joining me, little Katerina, and I will see you in the next video. Bye.